Good afternoon, everyone. My name is Emily Sumner. I am the attorney, one of the attorneys. We have another attorney who's joined us recently, Ashley Hale, but I am one of the attorneys here at Sumner Immigration Law, and I am happy to talk to you today about the H-1B cap in 2021 and what that's going to look like. If you would, in the chat, let me know that you can hear me. That would be very helpful before we get started. While I'm waiting for everyone to tell me, or someone to tell me that they can, oh good, people are telling me they can hear me. Awesome, thank you. We have a lot of information to get through today. I'm planning on this program lasting about an hour. I am hoping to talk for about 45 minutes and then leave some time at the end for questions. We have tried to add the questions that we received through the registration into the program, but if you have other questions, feel free to put those in the chat, either as we're going through the slides, I'm happy to answer them. I may save them for towards the end, or if it's relevant, I'm going to answer them as we go along. So definitely put questions in the chat box as we go along. So what we're talking about today. I'm going to quickly review what is an H-1B visa and the overview of the quote unquote new H-1B cap registration process. I'm going to spend most of the time or more time on the possible new regulations that may affect this H-1B cap season and H-1Bs in general, and then also talk about some timelines. So if you are new to the H-1B world, know that I'm not spending a whole lot of time on the more introductory aspects of this, but the information is there. We're happy to help you. We're happy to get you more information. Just let us know by sending us an email after the webinar. So what is the H-1B visa? We're going to talk about what is it? Are you eligible for an H-1? What is the H-1B cap? And why did the government last year change the H-1B cap registration process? So an H-1B is a temporary visa classification. It's valid for 6 years. A US employer has to file, so you can't just come into the United States and file an H-1B on your own. Self-employed H-1Bs are possible, but there's some restrictions around that. The H-1B is for professionals that are working in a specialty occupation, and that's defined in the regulations as an occupation that requires the minimum of a bachelor's degree in a specific field of study. So it can't just be any particular or any occupation, but again, one that requires a minimum of a bachelor's degree in a specific field of study. As you can imagine, that can be difficult, that can be tricky. That's one of the more strategic aspects of preparing an H-1B petition, is making sure that you're describing the position accurately, but in a way that shows that a specific degree is required. A lot of, as you all know, a lot of positions these days are multidisciplinary. So for example, in pharmaceutical development, we have some occupations, we've worked with clients before, where the position might require a degree in pharmacy or computer science, for example, for clinical data managers. So that's a tricky thing that we have to be careful of and attack specifically. There is a limit of 65,000 H-1B petitions every year, plus an additional 20,000 for US master's degree holders. So you might hear just on the internet or hear us talking as immigration professionals about the H-1B lottery or the H-1B cap. This is what it's referring to. It is referring to new H-1B petitions, meaning individuals who have never held H-1B status before through a private employer. Please know that there are some employers that are cap exempt. So specifically, that's institutions of higher education, certain non-governmental NGOs, non-governmental organizations, and certain nonprofits, but not all nonprofits. There are very specific regulations about that. So it's possible that a person would have worked for one of these cap exempt organizations and then changed to a private employer, and they would be subject to the cap because they hadn't been subject to the cap before. So again, a limit of 65,000 just in general, and then 20,000 for US master's degree holders or higher. Are you eligible for an H-1B? So when we're analyzing with the client or prospective client whether they're eligible for an H-1B, we look at, does the position require a minimum of a bachelor's degree in a specific field of study? Like I said, one of the main sources that the Department of Labor looks at is the OOH, which is the Occupational Outlook Handbook, and it's available online. If you Google OOH and then whatever position you're looking at, it should come up. Not every job title or occupation is in the OOH, which is sometimes problematic because it's not great, because we don't have an entry in the OOH that says specifically, yes, a bachelor's degree in computer science, for example, for a software developer is required. But it is nice in a sense because we have more room for argument. We don't have Department of Labor telling us this is exactly what the degree requirement is and what the field of study is. So that's a primary source that USCIS looks at is the OOH. So that's where we look as well, because we know that's where USCIS will be looking. And then we look at, do you have at least a bachelor's degree? So it's a two-prong analysis. What does the position require? And again, it has to require a bachelor's degree in a specific field of study or higher. And does the person, do you as the prospective H-1B employee have that degree and have that field of study? Even if you don't have that particular degree, we can sometimes use a combination of education and experience to get what's called a credentials evaluation that affirms that through your combined education and experience, you have the equivalent of X degree, which would be relevant to your position. So just know that even if you don't have a bachelor's degree in, let's say, again, using the software developer, although we have clients with all different job titles, but software developer, if you don't have a degree in computer science, but you have lots of years of experience, it's possible to use a credentials evaluation to say that, or to affirm that your combination of education and experience is equivalent to a bachelor's degree in computer science or whatever the required field of study is. So what is the H-1B cap? Again, we talked about this a minute ago. It's an annual limit on the number of new H-1Bs. So this does not include H-1B transfers or H-1B extensions or amendments for people who have already been counted against the H-1B cap. 65,000 in general, and then 20,000 for US master's degree holders or higher. For the US master's degree, it does have to be a master's degree, that was earned in the United States. It cannot be a master's degree or higher that was earned outside of the United States. And the definition and the regulation of US master's degree it refers to a regulation, a Department of Education regulation. But bottom line, what it translates into is that university has to be accredited and it has to be not-for-profit. So there are some universities from which you can earn a degree here in the United States that are either not accredited and or are not-for-profit organizations. So that's something we always look at when we have an individual with a US master's degree. We don't just look at the piece of paper and say, oh, this degree was earned in the US, it's a master's degree. We have to do further research and see, is that university accredited? And there's a Department of Education website that we can look on for that. And is it for-profit or not-for-profit? So the H-1B cap process, before last year, and some of you may know this, but before last year, we would prepare an H-1B petition in its entirety and file the H-1B petition with USCIS on April 1st. Then USCIS would receive all of the petitions. Most years, not all years, but most years, certainly for the past, I think since 2012, USCIS has received more petitions than they have slots available for. So they would take, before last year, they would take all of the filings that they received the first 5 business days between April 1st and whatever the subsequent 5 business days were, and conduct a lottery. They would first select the US master's degree petitions, the 20,000 US master's degree petitions, and then do a second lottery and select the 65,000. So US master's degree people had 2 chances. They were selected, like I said, for the 20,000 cap, and then they were put back into the general pool for the 65,000 cap. And then if a petition was not selected in the lottery, it was returned to us. So we would file, if you think about it, it didn't make a whole lot of sense because we would prepare the entire petition. Clients had to pay the whole legal fee because we were doing all the work, and the case may or may not have been selected in the lottery. And USCIS would spend lots of resources, time and energy and money and postal fees processing these petitions and then returning them, hundreds of pages back to us because the case was not selected in the lottery. So in 2020, last year, one of the many things that changed in 2020, not just immigration-wise, but in general, but one of the key immigration things that changed with an employment-based immigration is USCIS changed, and this is a regulatory change. They changed the process where they said, okay, it doesn't make sense for everyone to send the entire petition. We're going to do an electronic registration system. And we'll talk about what that looks like in just a minute. But the reason that they did this, and this was in the works, this was not necessarily a Trump driven regulation, unlike some of the other changes, but it was something that has been in the works for years and years before the Trump administration, I think before the Obama administration, it's been in the works for a while. So USCIS is they've implemented this to create cost savings and efficiencies for petitioners. Like I said, now petitioners don't have to pay the entire legal fee unless they just want to have everything ready ahead of time. And the agency doesn't have to spend all those resources sending back unselected petitions. And it also will further the goal of modernization. So USCIS is slowly working towards becoming an electronic filing-based agency rather than paper-based, which is what it is right now. So right now with the H-1B CAP process, with the new process, it's a hybrid. There's an electronic registration situation, and then there is a, got distracted for a minute, and then there is, you file by paper once you're selected, and we'll talk about that in just a minute. So the electronic pre-registration process, we're going to talk about in a minute. What is the lottery process? What does that look like? And then what information is required? So pre-registration, the electronic pre-registration process, USCIS will require employers to register any employees that they want to file for the H-1B CAP this year to enter into the H-1B lottery. Employers will be able to register, or their representatives. We did this for our clients last year, and we will again this year because it's not a straightforward process as much as they're trying to simplify it. But they registered on a specific USCIS portal. USCIS will announce when they're going to open, when the registration process will be, when the registration portal will be open. Last year, it was open from March 1st to March 20th. I anticipate it will be roughly the same this year, but I haven't seen an official announcement as to what their registration period will be. And I think there's a reason for that, which we'll talk about in just a minute. So petitioners will only be eligible to file a CAP subject petition for the person, I'm sorry, I should have changed this to for national, named in the registration. So let's say that an employer files 10 or registers 10 employees in the H-1B CAP, and 8 of those are selected. That's really good. Odd, but let's say the 8 of those are selected. The petitioner can then only file H-1B petitions for those 8 individuals that were named in the registration. They can't say, oh, well, this guy, John, he decided to file through another employer, or he went back to his home country, or whatever it is. You can't substitute out people, unfortunately. And there's also a $10 USCIS fee to register. That's the USCIS fee, just to register. There's, of course, additional filing fees once you file a petition. So under the new process, we register through this electronic system, and then USCIS randomly, and we'll talk about that question mark in just a minute because there's a new regulation that may change this, but USCIS randomly selects the H-1B registrations. In the previous system, before USCIS changed the regulations in 2020, in the previous system, the H-1B master's cases were selected first, and then the regular. They changed it with the new regulations so that now everybody goes into the general pool. The US masters and everybody else goes into the general pool. They select 65,000 there, and then they run the master's cap. Statistically, the master's cap lottery. Statistically, that makes it so that a US master's degree holder who is registered has a higher chance of being selected in the lottery. So they run those 2 different lotteries. And when I say that there are 2 different lotteries, it's not something that we see or that we know about. So in other words, when a person is notified that they are selected in the CAP case, or sorry, that they're selected for the H-1B lottery, they don't tell us whether they were selected in the master's degree or the regular classification. And it doesn't really matter, but some people think, oh, I got a notice, or I haven't been notified that I wasn't selected, so I guess I might be in the second lottery. No, they don't notify us that way. They just do it all at once and then notify people, and we don't really know which lottery you were selected in. They run the selection process last year. They ran the selection process, or rather they notified, we don't know when they actually did it, but they notified people starting at the end of March. I remember getting emails, I think starting March 28th, around there, March 28, 29, 30, and 31, notifying us that cases were selected. Again, that depends on when the registration process is, when the registration period is, and when they actually conduct the lottery, but it is supposed to be the first part of April. Then we have 90 days to file the petition after the selection. So last year we were filing H-1B CAP cases in April, May, and June. What information is required to register for the H-1B lottery? A lot of people are trying to get ready now, which is fantastic. I love it. We love it as a team. So people are trying to get information together. This is the basic information that was required last year in terms of the employer information, the legal name, the tax ID number, your office address, the person who's authorized to sign. I put wage level because that may be required for this year's lottery. We'll talk about that in just a minute. And then information from the beneficiary that's required, meaning the individual employee, is things like their name, gender, whether they have a master's degree or higher. So that's definitely an analysis we have to do before we register them in the CAP, the date of birth, country of citizenship, and passport number. So it is some information, but it's not pages and pages worth of documentation like we were filing before. Now we're going to turn to the possible new regulations, which I mentioned I would be spending them, hopefully the majority of, or some more time on, so that we can talk about it in detail, because these are the changes that could potentially affect this year's CAP selection process. So there are 3 different rules. The first rule is a Department of Labor wage rule. The final rule was published on January 14th, 2021, so just last week. It was originally published, you may remember, if you are in the H-1B world at all, or employment-based immigration world at all, you may remember that this particular rule was first published in October 8th. There was litigation about it. You may remember that the wages went way up. And when I say wages, I mean the prevailing wages, which you're required to pay and employers required to pay by law. But that particular rule was blocked by federal courts. And it was due to, the court said that they violated, the agency violated the Administrative Procedures Act. It's a technicality, basically, that they didn't follow the regulations in the Administrative Procedure Act, or the rules there. So they blocked it, and then the wages went back to quote unquote normal, what they were before, and that's what we're filing H-1Bs, extensions and transfers on now. This new rule is supposed to take effect. This gets complicated, and bottom line is we don't know what's going to happen exactly or when. So you may come away from this webinar with more questions than you had before, but that's good, because at least you'll know what questions you have now and what may be coming up on the horizon. So this regulation is to take effect on March 15th, 2021. But there are transition periods built into the regulations, unlike before. If you were involved with H-1Bs or are involved with H-1Bs, preparing them on the employer side, or if you're an employee yourself, you may remember that on October 8th, they published the regulation and it was effective immediately. We had 0 advance notice. It was not a fun time. But it's supposed to take effect March 15th. There are transition periods. However, there is going to be tomorrow, as you know, Biden is going to be Biden is going to be inaugurated tomorrow, put into office tomorrow on Wednesday, January 20th. And it has been said, will issue a presidential memo that will delay these what is called midnight rules. So midnight rules refer to these regulations that the current administration, the Trump administration, is pushing through at the last minute. This is something that has been done traditionally. This is not a new thing that the Biden administration has thought up. It's done traditionally. The idea is to allow the incoming administration a minute to just acclimate, get into office, take a look at the regulations that are supposed to be coming into effect soon. It's typically within 60 days, and to decide what they want to do about it. Do they want to let it go forward? Is that in line with the strategy that they have set out, or do they want to try to further delay it, delay the implementation, or try to undo the regulation altogether? We don't know exactly what the presidential memo is going to say in terms of timing, and we'll get into that more in just a minute. The other thing to keep in mind about this DOL rule is that it was litigated the first time. Like I said, it was set aside or blocked by the federal courts under the Administrative Procedures Act. And I fully anticipate that there will be litigation again. We have no idea, of course, if it will be successful or how successful that litigation will be, but I do anticipate that there will be litigation, which means possibly constant changes. The DOL wage rule that I have been talking about just now, this is an overview. This gets pretty nitty gritty, but I wanted to give you an idea of how much the wages might go up, because that's always a question that people have. The new wage schedule has not been published. It will not be available until it actually is effective. But we do know that the DOL wage rule is changing the way that these prevailing wages are calculated. And to go back for just a minute so that everyone knows what a prevailing wage is, when an employer files an H-1B petition or a green card, employment-based green card process, the employer has to attest that they will pay either the prevailing wage, which is set by Department of Labor, which is what we're talking about here, or the actual wage, which is what they're paying similarly situated workers, whichever is higher. So and it's called the prevailing wage. It's determined by the Department of Labor, and it is something that is non-negotiable. You have to pay the higher of the prevailing wage or the actual wage. It is collected, the Department of Labor collects data and from all over the country and all different occupations. It is geographical. The prevailing wage is geographical. So when you're looking up the prevailing wage, you look up the occupation by standard occupational code or SOC code, and you search by geographic location. So it's not a national average or anything, but they look at information at data as to how people are paid in specific areas, specific occupations. And this page, the slide here, shows us what the new wage levels will be versus what they are right now. So wage level 1, the new wage level 1 will be the 35th percentile of the data that they collect. And right now it's 17th. So as you can see, there's a huge discrepancy between 17 and 35. Wage level 2 will now be the 53rd, that should say for 53rd percentile versus the 34th, level 3, 72nd versus 50th, and level 4, 90th versus 67 before, which is huge, a huge discrepancy between what is possibly coming and what we have right now. Just to give you an idea in kind of real life practice, multiple media sources have said that the average increase in prevailing wages for occupations such as, these are some of the more common occupations, not all by any means, but some of the more common occupations for the H-1B, such as biochemist, biophysicist, software developer, database administrator, computer programmer. I'm not sure why they included that. I would never file an H-1B for a computer programmer, but anyway, in general, they've done the computations, and in general, there's supposed to be a 28 to 34% increase in wages between what the current wage levels are, prevailing wage levels are, and what they will be in the future under this new rule. One thing to note is, this sounds bad and it's not great at all. But one thing to keep in mind is that these wage levels, the new computation under the new rule, is the wage levels will be slightly lower than they were per the October 8th regulation. So if you're thinking back to the October 8th regulation and thinking, oh my gosh, there's no way we can do this, it still may not be favorable. It may not be amazing for employers and their employees, but it's not likely to be quite as high as it was before. As I said, there are transition periods built into this, and this is where we're talking about how this could affect how this particular regulation could affect or not the upcoming H-1B lottery. So the regulation itself says that there is a delayed implementation period. The current wage levels are in effect until June 30th, 2021. As I said, we will file H-1B cap cases starting April 1st, and then we have 90 days to file. So bottom line is these wage levels should not affect the H-1B 2021 cap season, which is fantastic. And the other thing is these wage levels will not be retroactive. So in other words, once you file, then it's that wage level for the duration of that particular H-1B petition. When you have to file an extension, or if you have to file an amendment, then of course the wage levels will be whatever they are at that particular time. There's a 1-year transition period where the wage levels will be 90% of the final wage level, and then as of July 1st, 2020, in about 18 months, 100% of the final wage level will be required. I would imagine that the Department of Labor website that we use to calculate these wages or determine what these required wages are will be updated automatically, and we're not going to have to calculate what 90%, not that that's a hard calculation, but I think that will be on the website and we won't have to do that calculation ourselves. Bottom line for H-1B cap season is the new wages should not affect the 21 cap cases. That will not be true for 2020, assuming this regulation stands. Sorry, for 2022, but for now, we are grateful that they should not affect the 2021 cap cases. Everything is subject to change. Of course, things are changing rapidly. They have been for a long time now. So if that changes, we'll definitely let you know, but this is the way that things stand right now. The second regulation that may affect the H-1B cap cases is strengthening a regulation that's named Strengthening the H-1B Non-Immigrant Visa Classification Program. It's quite a mouthful. The final rule as of yesterday has not been published. We don't know exactly when it will be published. Again, this is similar to a rule that was published October 8th and was supposed to be implemented later, but it also was struck down by Department of Labor, supposed to be implemented in December of 2020, but it was also struck down by the federal courts. I think I said Department of Labor, but I meant federal courts as part of the lawsuit that I was telling you about that also struck down that DOL wage from October 8th. So it's not published yet. It is similar to the rule that was published October 8th. The main changes to the rule are they changed the specialty occupation definition, which will be interesting, and they changed the definition of some of the elements of the employer-employee relationship. And that goes to instances where an employee is placed at a third-party client site. So they're not working directly at the employer's headquarters, but rather they're placed at a client site. Again, I anticipate regulation for this particular, I anticipate litigation for this particular regulation. Again, we don't know how successful it will be or to what extent or when. This regulation also will be effective, if it becomes effective at all, 180 days from the publication date. So, given that 180 days from now is beyond the summertime, or in the summertime, it should not affect the H-1B cap for 2021. It would for the future years, and it would, of course, for extensions or transfers in the future, but it should not affect cap cases this year. Finally, the third rule that I wanted to talk to you all about is the wage-based selection system. This is a final rule that was published January 8th. Pursuant to this rule, USCIS would select H-1B registrations based on wage levels. Remember our previous slide, I said that they randomly, and then I put a question mark in parentheses, select the H-1B petitions and the registration through the lottery. And this is why I put the question mark, because we don't know if this particular regulation is going to be effective. This would significantly alter the H-1B lottery process. USCIS would select based on wages, like I said. Wage level 4, the highest wage levels, would be selected first, and then they would go down from there. So wage level 3 then would be selected if they haven't filled all the slots that they have available, and then 2, and then 1. The agency and various media sources anticipate that no wage level 1 registrations would be selected based on this particular system. This system goes more towards a skills-based or wage-based selection process that Trump has advocated for over the years. And we'll talk about what Biden's view might be on that in just a minute. So the rule is published, like I said, it's supposed to take effect on March 9th, which would be right during the registration period, assuming it opens on March 1st. As I said, the presidential memo that we anticipate to be issued tomorrow by Biden would probably delay the implementation for at least 60 days. However, the wording of that memo matters, and we don't know right now what the wording of that memo exactly is going to look like. So this rule could be implemented on March 21st of 2020. That would be 60 days from the presidential memo. So in other words, Biden could say, okay, all of the regulations that are supposed to take effect within 60 days, I don't know exactly what the timing will be, but within this time period, we're going to delay for 60 days, and that would be March 21st, which could possibly fall within the registration period. We'll talk about that in a minute. Or the implementation could take effect May 8th. That's if Biden's memo says that he's delaying the effective date for 60 days from the regulations effective date as published in the Federal Register. I know that's confusing. Don't worry about the timing. I mean, that's easy for me to say. It's going to possibly affect you, but don't worry about the timing right now. We'll have lots more information on this tomorrow and the rest of the week in terms of what the presidential memo says, and then how this will affect the implementation of this rule and the timing. But just know that the wording of the memo matters, and that we should have more information later this week once we have that memo. Going to the registration period, I said it could be effective March 8th of 2021. Per regulations, the H-1B registration period has to begin at least 14 calendar days before the earliest date of filing the petition. That, by regulation, is April 1st of every year of 2021. So the latest date that we could file, or the latest date that they could start the registration period, I think would be March 18th. Logistically, with either of these potential implementation dates, March 21st or May 8th, it would be very difficult, I think, for USCIS to implement this rule into this registration system if the registration is supposed to start in March, which it is. It has to start in March. So I don't know that this can, given the presidential memo, I don't know that it can be implemented this year. I think that it's very possible that it would be pushed to next year, but we don't know that for sure. It's possible that it would be implemented this year and that the registration period would be pushed back to the second half of March. We just don't know yet exactly what's going to happen with that. What else may happen with this particular regulation on the change and the way that petitions are selected? Litigation is likely. This is not consistent with the statute. The statute is something that the agency can't change. The statute is written and voted on and passed by Congress and signed into law by the president, whoever's president at the time. So it is not consistent with the wording in the statute. So I think litigation is very likely. I think it's possible. There's a very good chance that the litigation would be successful. Again, we can't make that guarantee. We don't know what the timing would be, that kind of thing. The other thing is, do not assume that President-elect Biden will support getting rid of this particular regulation about the wage-based selection. So like I said, it could be struck down, it could be delayed by the presidential memo, and we talked about the dates in which it might be implemented. But don't assume that Biden's going to walk into office and then say, oh yeah, we're going to get rid of all of these regulations, including this one, the wage-based selection system. The reason I say that, and it may not stand up in court, so it may be struck down even if Biden wants to have something like this in place. But the reason I say that is if you look at his immigration plan, which is available online, it references trying to put into place or wanting to put into place a wage-based allocation process and establishing enforcement mechanisms to ensure they, meaning the wages, are aligned with the labor market and not used to undermine wages. So Biden's overall, we talked about this in last month's webinar, Biden's overall approach, I think will be similar to Obama's, and that he is going to be about enforcement and compliance so that he can show that he's making that effort to, other people who may be more opposed to immigration reform. But he may be, I think he'll be focused. It says it in his immigration plan that he'll be focused on enforcement and compliance. I think so that then he has more room to push for immigration reform, something for, dreamers or people who are here undocumented. But anyway, I think that we can't assume that Biden is going to say, oh yeah, that's a terrible rule, let's get rid of that as soon as we can. I think it's something that he could actually support. So we're done with the regulations. I'm going to check questions real fast. Nobody has questions. Okay. If you have questions about those regulations or anything else that we've covered so far or something we haven't covered so far, put them in the chat box. We're at 12:35 and I have a few more slides to cover, but then I want to answer questions that anybody has. So the implications, these are the implications now of the overall CAP process. I'm not talking about the regulations anymore specifically. I'm talking about the implications of this lottery process. The implications are an increased number of petitions. We'll take a look at numbers in just a minute. The danger of registration without a proper analysis. And then the timelines change for the case submission, preparation, and adjudication. And we'll talk about those in detail. So increased number of petitions. As you can imagine, it is easier to file a petition, or rather to enter somebody into the H-1B registration system to be included in the lottery and pay the $10 fee, even if you pay us to help you through that registration system. That is a lot less work and less expensive than filing a whole H-1B petition with USCIS, and much less work. So it's an easier process. There's a lower barrier to entry is what I'm trying to say. So we anticipated last year that would significantly increase the number of petitions. I say petitions received, but I mean registrations received in this case. This is a history of the number of petitions received the past 6 years. As you can see, from 2019 to 2020, there was a significant increase, 75,000 approximately additional registrations were submitted up from 2019 when you had to submit the entire petition. That being said, you can see through this historical data that the numbers have varied over the years, and it just depends on a number of things, including the economy, H-1B adjudication trends. A lot of times foreign nationals will come from, filing for the H-1B will come from schools. So it depends on how many foreign national F1 students we have, that type of thing. But it has varied a bit over the years, not nearly as significantly as what we saw from 2019 to 2020. But there's an increased number of petitions, which means you have, in general, a lower chance of selection, just statistically speaking. There is a danger of registering without proper analysis because, and this is something that it's a community-based, I guess, concern. Because if you register someone without looking at, is there actually work available for this person to do come October 1st, which is when the H1 earliest date that the person could have H-1B status. And does this particular occupation requires a specialty occupation? Does it require a minimum of a degree? Are we able to pay the prevailing wage? And that will be determined by the SOC code that you select. So there's a lot of analysis that goes into making sure that your case is actually viable. If you register a person, an employee, who without doing that analysis, and then your case is selected, first of all, you're spending time and money on something that may not be successful. But then secondly, if that case is selected, then you have the option of either filing a case that's not viable and probably will not be approved, or not, and you just waste that space, and then somebody else isn't able to take that slot. So that's why I said it's a community-based, it's a group project in a sense, but community-based concern. But it's a big deal because there are so few H-1Bs, relatively speaking, available, and so many people who want them and have so much to add to the U.S. economy and job market, and then they go on to get green cards and create jobs. So that's something that you want to take into consideration. You don't want to just file lots of registrations just to increase your chances and then take up slots that other people could actually use. That being said, last year, there was a second round in the lottery, and we had, I think, 5 clients notified that they were eligible to file. So USCIS does take a look at that, but it's inefficient and people can't plan if they're selected later necessarily. So that's something to keep in mind. The timelines, and we have one question that came in. How long do we actually need to prepare for the petition materials if selected in the lottery by early April? Yeah, we'll talk about that in just a minute. So the overall timelines for this year are if you know that you would like to proceed with the H-1B registration, let us know that you would like to proceed. You can send an email to info@Sumner Immigration or my email address, and we're happy to help you get started. But that's something that you would need to do at least by February. Let us know. During the rest of January and February, our team will be working on case analysis. So like I said, making sure that a case is actually viable to file, and the registration preparation. That being said, I want to put a caveat out there. I just spent time talking about these 3 regulations that we're not sure exactly if they'll be, when they'll be effective or if they'll be effective. So we are delaying the case analysis just a little bit, I would say for another week or so, to make sure that we know exactly what rules will be in place, because we could spend our time doing all of this analysis and coming up with a plan based on regulations that may or may not be in place. So we're waiting until the Biden administration issues that memo, so we have a little bit clearer information on how to plan properly. Register cases, last year, like I said, it was March 1st to 20th. And our process last year was we gathered the registration information in February so that we were ready to file, to register on March 1st. It doesn't really matter when you register as long as it's within that registration timeframe. I put a question mark there because, like I said, they may delay the registration period depending on when those regulations that I talked about become effective. And then we'll file cases from April to June. Again, well, that I think is pretty set, but because the first date to file is in April. So you would file in April to June, and then you would have a decision anywhere between April and November or possibly beyond. The processing time really varies. It is possible sometimes to file a petition in premium processing, which means you pay an additional $2,500, that's the current fee, to USCIS, and you get a decision or request for evidence within 15 days. But sometimes they suspend that, especially around the H-1B cap season. When they anticipate a big influx of filings, they'll temporarily suspend the premium processing. Last year, they suspended, in 2020, they suspended premium processing when COVID hit. So it wasn't necessarily directly related to the H-1B cap, but just keep in mind that may not be a possibility. So you would have a decision, hopefully between April and November, sometimes beyond, if there's a request for evidence and it's still pending. So and I know I didn't specifically answer the question about how long to prepare, so I'll answer that in just a minute. What we can do for you, like I said, we help clients with a pre-registration case analysis. We look at the beneficiary's educational background, their experience, their position details, the job duties, the proffered wage. We help the employer determine what SOC code might be appropriate. Are they able to pay that proffered wage? That kind of thing. We also help employers walk through the electronic registration. We actually do it for them, but we gather the basic information that we need, have employers confirm that, and then enter the information into the CAP registration system when that is open. Then, of course, we notify employers as we get the notifications, and employees as we get the notifications. And then we prepare and submit the selected petitions between April and June during that 90-day time frame. So the next steps, and as I said, we're coming up to the question time. So if you have other questions, put them in the chat box and I'm happy to help you with that. The next steps, if you are a new client and you have not worked with us before, or at least not on an H-1B cap petition, set a time to speak with us. Emily or Ashley, my apologies, I should have changed that to Ashley, but set a time to speak with us to come up with a strategy Then retain us for the initial case. That's sending an email to us. We would send you the engagement letter, which is the contract that outlines the fees, and we would send information on the information that we need for the registration process. If you are an existing corporate client, set a time to speak with us to discuss the case preparation strategy. To make sure, just give us a number of the estimated number of cases that you want to file. We can talk about how these regulations may impact you and that kind of thing. Just come up with a plan and make sure that we're set to go when the registration opens. So to answer this question about how long, this is a great question, how long do we need to prepare the petition materials if selected by the lottery in early April? One option, you have a couple of options. One option is to say, you know what, if I'm selected in the lottery, I want to be able to file as soon as I possibly can. And you could retain us to actually prepare the entire case. That way, if you were selected in the lottery, we would have everything ready to go and be able to file by that first week of April. The downside is if you weren't selected in the lottery, then you would still be paying those legal fees for us having prepared the entire case. If you decide you want to wait for the H-1B results, for the lottery results, before you invest the time and money to prepare the case, which makes sense, I would say it would probably be at least a couple of weeks. We have to file the LCA, the labor condition application, and have that certified. Right now, that's taking 7 days. It is taking 7 days by regulation. It's taking it's typically 7 calendar days. So I would say within the first couple of weeks of April, and then going forward, we would do everything on a first in, first out basis. So as soon as you get us the information, we would put you on our list and then file in that order. So I can't guarantee that everybody would be within the first couple of weeks, depending on how quickly people get us information. Last year, there were a handful of clients that got us information very quickly, and we were able to file within the month of April. Other clients were not in as big of a rush, like they had STEM OPT or other ways that they were able to keep working or stay in the US, or they were overseas, and they got us the information in May, and we were able to file still within the time frame, but not that first in April. Another question, are we expecting any increase in filing fees? As of right now, no. As of right now, the USCIS filing fees are staying the same. There was a regulation, as you all may remember, a regulation rule to increase the filing fees in October of 2020. That was struck down, and I don't believe that will come back up. I could be wrong. Everything's subject to change, but I don't think that will come back up. If anyone else has any questions, put them in the chat box, and I'm happy to help. Otherwise, we're going to move to ways to stay updated. As I've said throughout this presentation, there are so many changes, not just to immigration, to the H-1B CAP process, but to H-1Bs in general, and to employment-based immigration law, family-based immigration law, all of the things that we work on as a team at Sumner Immigration. So ways that you can stay updated are read our blog posts. We post on our website, sumnerimmigration.com. Join our email newsletter if you have not already. You can join by going to our homepage, sumnerimmigration.com, and putting your email in the bottom right. And there's an email sign up for our newsletter. We publish the newsletter the first week of every month. We don't share your information with anyone. And of course, you can unsubscribe if you ever wanted to, which you wouldn't, but if you wanted to, you could. And then RSVP to future webinars. I anticipate that we will have a similar webinar to this in February with updated information as to how these regulations would impact the H-1B. But if it's not about that, if there's not big changes that we are aware, we'll have a webinar on a different topic. We have these monthly webinars. It's usually the second Wednesday of every month. We did this now to just get a little bit more information about these regulations rather than the second Wednesday, but it's usually the second Wednesday of every month, so we hope that you will stay connected. If you have questions that you have not put into the chat box, please feel free to send us an email. You can email me or email info at sumnerimmigration.com, and we are happy to help you. Otherwise, we also post on social media, updates on social media, especially my LinkedIn page, my personal LinkedIn page, Emily Sumner on LinkedIn. We post updates there regularly all the time. If there are no more questions, I really appreciate you joining us. I hope that you found this helpful, and we look forward to helping you navigate the H-1B CAT process this spring. Take care.